I'm Maricela Segura. I'm an attorney with the Western FTC's office in the Western region, Los Angeles. I've had the pleasure to work shoulder to shoulder with my FTC colleagues on debt collection enforcement actions, but I've also done the other side where we've done education outreach, shoulder to shoulder with folks in the industry. And so this is a continuation of that effort. And I'm very excited to bring you a panel of folks in the industry, folks that do counseling for limited English proficient consumers, especially Latino consumers, and also folks who do enforcement. And I would like my panelists to introduce themselves and give you a little bit of their background and in this industry, starting with Albert Cadena.
Good morning. My name is Albert Cadena. I'm with USCB America, located here in Los Angeles. We're a receivable management company. Predominantly 99% of it's healthcare related front-end revenue cycle as well as collections. We do a variety of different things for Latino consumers, predominantly because of most of our facilities that we engage with and partner up with are in predominantly Latino areas. So just wanted to kind of share my experience with that as well. And I've been with the company for about 32 years and looking forward to the day. And this morning was a great startup and looking forward to engaging with you guys.
Hi, my name is Barney Eskandari. I'm a Deputy Attorney General in the California Attorney General's Office. This year we're celebrating our 165th anniversary of enforcing the laws of the state of California. I'm in the consumer law section. We are responsible for enforcing the state's consumer protection statutes. This includes Rosenthal Fair Debt Collection Practices Act, which is an analog of the federal law. Thank you. It's an analog of the federal law, but a bit more, has some slight changes that I think are favorable to California consumers. We prosecute individuals and corporations. I'm particularly fond of banks. Deputies in my section handle all aspects of prosecution, from investigation to trial to appeal. 3 quick examples of cases that we've recently handled. The $25 billion joint federal-state settlement against 5 of the nation's largest mortgage servicers. We just entered a settlement with Aaron's Inc., one of the nation's largest rent-to-own companies. That settlement includes a $25 million restitution component that's going to be paid out directly to consumers. We also recently sued Chase Bank for rampant debt collection abuses in hundreds of thousands of lawsuits against California consumers. This is a case that I'm currently working on, so I'm right in the thick of these debt collection issues. Quick disclaimer, I don't speak for the office, I don't speak for the AG. I'm here for my, the thoughts and views provided are my own only.
My name is Mark Naiman. I'm Chief Operating Officer at a national debt buyer out of San Diego by the name of Absolute Resolutions Corporation. We've been open for 14 years. As I said, I'm a national non-medical buyer, where Mr. Cardenia and I are very different, is that we do no medical collections. I am also an active board member for DBA International, which is the trade association, Debt Buyers Association. I was integral in helping to create the certification program, which Debt Buyers Association has recently rolled out to the industry as a means of self-policing actors that are, as you'll hear on this panel, a lot of worst-case scenarios from consumers reporting these things to the various trade associations. Like I said, in the 14 years we've been open, we've purchased a national range of products, from credit cards to installment loans, mortgages, second mortgages. And over the last 4 or 5 years, we've been on the front line of ensuring that the paradigm shift from the older models of collections 10 or 15 years ago have moved towards a compliant nature, and working with the banks to ensure that we're keeping with the highest levels of compliance in the industry.
Good morning. My name is Carla Priego. I'm here representing ClearPoint Credit Counseling Solutions. ClearPoint Credit Counseling Solutions is a nonprofit organization with over 50 years of experience, and our mission is consumer health through financial education. We are committed to helping our consumers in the local communities we service by providing financial information and guidance in order for them to be able to handle their finances and be able to make better educated decisions.
Well, good morning, everyone. Great to see so many familiar faces and new friends that we hope to meet throughout this event. Rigo Reyes, Chief of Investigations with the County of Los Angeles Department of Consumer Affairs, the only local county Department of Consumer Affairs in the state of California, and certainly a resource for consumers for all types of consumer issues. Debt collections clearly one of the top priorities. One thing we do at the department is take individual complaints for one-on-one follow-up and assistance. That's in addition to looking at patterns of complaints, violations, to investigate cases that we refer to our partner prosecuting agencies, regulatory agencies, for assistance in correcting broader issues. So I hope that today we can learn about some of the things we're looking at, things that we feel would help the industry and consumers in carrying out the businesses that they do.
Good morning, I'm Allison Snow. I am the Senior Attorney for the Consumer Protection Division at the Legal Aid Society of San Diego. We have a two-prong approach to dealing with debt defense. On the first end, we help people through the pre-litigation process. So we do all aspects from engaging people on how credit is acquired. And so we go out, we reach out to the seniors in high schools on what they need to know about turning 18. And because they're the next generation of consumers taking out credit. And then we also have programs internally where we provide legal advice regarding debt collection. And then if it all goes bad, then we've set up 2 debt defense clinics in San Diego County. So we have one in our South County courthouse and one in our North County courthouse. And these are being used as a national model. Through these clinics, we've been able to help thousands of defendants in debt collection actions. We also bring affirmative actions when there's been violations of the Fair Debt Collection Practices Act or the Rosenthal Fair Debt Collection Practices Act, or problems with the underlying credit transaction. And so we have a lot of clients, and we're really struggling to get on top of this issue in San Diego. And because of our location, we have a large percentage of our clients are either monolingual or limited English proficient Spanish speakers. And so we are really focusing our efforts into reaching out to those communities.
Thank you, Allison, and everyone on the panel. As I said, we're very excited to have a mix of folks across the range of industries and enforcement and counseling. We're talking about pre-litigation collection from Latino consumers. And we're talking about folks that are in debt, people that find themselves in the debt collection process for a number of reasons, whether it's legitimate debt or the result of some unscrupulous practice that causes them to fall into debt. And to examine this issue, we want to talk about how working with the limited English proficient Latino consumers affects the debt collection process. So first question, possibly for Albert or Mark in the industry, is when do you first learn that a consumer in debt is limited English proficient?
I can start on that. The first communication that we have with the consumer is when we first learn about the limited English proficiency of the consumer. We have bilingual collectors that are ready and handling the calls, inbound calls, after the notices go out, whether we do outbound or inbound. Majority of them are the inbound, or we do have consumers come into our office wanting to, with the letter that they receive, wanting to communicate to get a better understanding of why they owe the bill and what's the reason why they got the notification. Our notices are in both English and in Spanish, but there's still always some kind of explanation that is needed and to explain to them as far as why the bill is owed. So that's the first contact is basically when we first initiate the understanding that they can speak Spanish.
Mark, we've talked about this before. So if you buy a portfolio and you have a list of consumers there and what they owe and to whom, or the original creditor. Do you know the language of origin that contract, the credit contract was negotiated in? Do you know what the person's primary language is?
We do not. So when purchasing a portfolio of loans, and in our pre-conference talks, it was a very interesting discussion because oftentimes, as Albert has stated, the first time we're aware of the fact that there is a language other than English that is the primary language is on first contact. And for us, we have very few walk-ins. We have very few physical payments in our office, and even letters that go out in English. If the primary language is Spanish, typically that's not known until we make first phone contact. To take that just a bit farther, the data files that we receive, there is no primary language flag of the approximate 700 transactions that we've done over 14 or 15 years. I would say that there's only been 1 or 2 files which are very, very small, local, demographically isolated, whether it's furniture stores or rent-to-own type products, that have identified that the primary language was something other than English. Other than that, it's in many ways, a demographical guess. And so it's very important for us to ensure that we have the systemic controls to identify it on that first call and to get it to somebody who can speak in that primary language.
If I can just jump in here, I've raised this with some of the members of this panel, and I think this is symptomatic of a larger problem in the industry in general, and that is lack of documentation from the original creditor provided to the debt buyer, and that lack of documentation, unfortunately, gets worse as the debt is resold. So this falls under the rubric of one of my general concerns or best practices, that I think more documentation from the original creditor to the initial debt buyer at least could help mitigate this issue.
So when, say you find a portfolio and one of your collectors or someone finds that someone speaks a language other than English and needs to proceed in a language other than English, is the file forever changed or notated that whomever speaks to this person or whatever notice goes out should go out in another primary language?
Speaking personally, for us, the systemic processes that we've put in place are through our CRM, our contact record management. Once an account has been identified, and for simplicity's sake, consider it a Spanish desk. Fortunately, we're in San Diego. We have both my receptionists are bilingual. We have, of the 45 collection staff, I would say about 25% of them are bilingual. I have some speakers that speak Mandarin. I have 2 or 3 people in the office that speak Tagalog. And in the rare case that we run across somebody that speaks, Russian or something else, which is, again, very, very few and far between, we have the methodologies in place to be able to isolate those accounts so that future attempts at collections, if there are any, are in that native language. But unfortunately, just like Bernard indicated, it does have a lot to do with origination. If you look in a situation where somebody goes into a mall and applies for a merchant credit card is a clothing store, buckle or jeans or something like that. Oftentimes, the entire application process is done on a point-of-sale machine. And so the entire contract is there, and when we're dealing with people that are non-English speakers, but more specifically in Hispanic or Latino communities, oftentimes you'll have a few family members that are helping the primary consumer fill this application out. And so it may be displayed in Spanish on the screen, but what controls are in place to ensure that that person has really understood the nature of that agreement? And so, again, just to kind of dovetail into that, we make our best efforts based upon our first communication, and I don't know a better way for us to do it.
If you could, go ahead, Albert.
Just to add a little bit from our experience, and absolutely, I agree with Mark 100%. I mean, there was a health center client that we are currently in contract with that does have a field of giving us some data that this particular consumer is Spanish speaking. Challenges we've had is that if we went directly and communicated with them in Spanish without having communication with them, in some cases they get offended, and because they speak English as well. Spanish may be their primary, but they speak English as well. So an error of caution, just in the event that if we do get the demographic information, I think it's best that we communicate first, and if they speak Spanish and they prefer to do that, As Mark and I had stated, we have bilingual collectors that can do that and communicate with them fully.
If you had your wish list of when collectors are going to start collecting on a particular file or with a particular person, what information would you have in hand before those collection efforts started? And assuming that the person on the other side of that is a limited English proficient, what would you have?
In our situation, we have access to our client systems, which gives us a lot more information that we currently have. We get a lot of demographic information in our files, but 90% of our clients that we have currently today give us access to their systems, which enables us to tell them exactly why they owe the bill. Is it deductible? Is it a copay? Keep in mind we're in the healthcare services, so there is a lot of misknown. I was a patient, I walked in, I gave them my insurance card, I gave them my Medi-Cal card. Why am I being billed? Unfortunately, there is a copay, there's a co-insurance, there's a deductible of some sort. So once that's all explained, then they understand, and then they understand the reason of the bill.
Mark, in a perfect world, what would your collectors have in hand before they start a collection call?
We would have every piece of documentation that had to do with the origination of that loan. Unfortunately, I realize that that is an idealistic request. There's no way for me to answer this in just one way because certain loan types require different types of documentation. For example, credit card contracts, the actual credit card application, such a large majority of these applications are being done either online or over the phone. And so there's not a physical signature that's available, and this is a well-known topic. This is not new information. When you deal with something like an auto loan or mortgage loans, typically the amount of documentation that's available on these types of loans, you do have physical contracts, you do have signatures, and again, each deal is specific, each bank is different, each finance company, credit union, or associated financial institution has a different documentation policy. The great news about this is that having such a long experience within the industry, I can tell you that, especially since 2009 and 10, most major banking institutions have gone towards digital record keeping. So the availability of having digitally scanned or digitally available documents has increased tenfold. Idealistically, again, every piece of paper that would document the entire chain of that, the terms and conditions of the loan, the application, a signed contract, and a statement that would match the balance that we've purchased in an idealistic situation.
Carla, you've had experience at ClearPoint doing counseling with LEP Latino consumers who are maybe confused or want more information about the debt collection process. What are they reporting to you about their experiences in debt collection, the communications to them, the letters they receive? What are you hearing from consumers?
Generally speaking, we see a little bit of different scenarios. There are some clients that have no knowledge of that collection debt. Some don't have any documentation from any of their lenders. We also see clients that have received collection calls and don't understand the information that's being provided for them and don't have a way of communicating effectively with the collector. And so there's different scenarios that we see. The lack of information is, I think, the most important one.
Rigo or Allison, are you finding LEP Latino consumers talking to you or your staffs about the fact that they're not receiving these communications in their native language? Or has that been an issue for consumers that come to your offices?
Yeah, and in my experience, a lot of the clients come in, and if they do receive written documentation, that documentation is about 90% in English, and so they're not receiving their communications in Spanish. So in addition to basic difficulties in understanding those documents that anybody on a good day has, the additional barrier of it not being in your native language is very difficult to the clients.
You know, I was going to say, I think it's very important to take a step back and look at, the junctures, when these consumers jump into a situation that eventually leads to the collection of that debt because the account defaults. And what we see with many of our consumers who call us, they're not dealing with your traditional credit card account, card purchase. It's other types of accounts that they get into and eventually lead to collections. I understand things through stories, and I always refer to my grandmother's story. And I think she's representative of a lot of the consumers that we see dealing with these issues. She came to the States nearly 40 years ago. She speaks very limited English. She's done relatively well financially. I mean, she owns real estate property without understanding the language, yet she's never applied or got a credit card. She never bought a car. So she never got those traditional types of loans that some of the consumers have to deal with. But she got into trouble concerning typical purchases, sales that a lot of consumers like her fall for. And this is what I define as affinity marketing, where certain products are marketed directly to people like her. There was an infomercial that looked like a soap opera, very popular with her generation. Advertising an English course, how to learn English quickly. She looked at it, she liked it, she connected. The infomercial basically said, if you buy this course, you're going to be successful. Not just about learning the language, but you're going to, it portrayed the son-in-law learning English and quickly jumping from being someone who nobody liked to being the manager at the company. Well, my grandmother decided that her son-in-law needed that course, and she bought it for him, not for her. And, clearly my uncle didn't become quite successful as quickly as my grandmother expected. Her concern was that every time she visited them, the package, these beautifully packaged DVDs, were sitting on a shelf, unopened. And I don't know what it was. At every place I went, my cousins, my aunts, my tias, they had bought the same course, $1,800. And it became sort of a showcase. Well, my grandmother, when she finds out that my uncle is not benefiting from her investment, she decided not to pay. And so she got into trouble. The account was transferred to collections. And eventually, the calls that were coming in, the threats that she was receiving, she was terrified, just answering the phone. She's a very strong woman, yet she was very intimidated. So she would always ask me, what if my neighbor gets into this kind of trouble? What would she do? And eventually I said, Grandma, I know it's you. What did you do this time? And she said, well, she told me the story. By now she had paid almost $3,500. Every time, she would go to the local store and wire some money. Her thing back to the debt collector was, I didn't buy this thing from you. I want to talk to the company that sold it to me because I want to tell them that it didn't work. The response was, now it's our account, and even though they had no documentation whatsoever, they requested that she keep sending the payments. Now, I counsel her, I advise her, I gave her, paperwork. The minute she got on the phone, she forgot about all that. She got nervous, she panicked. She needed someone to handhold, the process, take the, and help her. I think we have a lot of consumers who are in that situation. And every time I get a call, I have to think about my grandmother, how she handled that situation, and what's real help for them. Is it outreach? Is it education? Is it hand-holding? Is it action, enforcement? And I think that's what this discussion needs to bring to light, some practical help that is actually going to make a difference for people who need to collect that debt that is owed them, as well as those consumers who, in the case of my grandmother, there were several violations when she bought that product that I don't think she was responsible to pay any penny back, regardless, including the lack of in Spanish, 3-day right to cancel when the person came to her door to sign the deal.
So, thank you, Rigo. So bringing it back to doing it right. If you had to do right, it sounds like you would have letters in language of origin, which Albert, you say your agency already sends out letters in Spanish as a matter of course, or is it because you've identified the person as speaking Spanish?
No, we just automatically do that because of the areas of where our clients are, which is predominantly Latinos. It just makes sense.
And Mark, you've said that in an ideal world, you would have a collector who speaks the consumer's language of origin, as well as, a script, presumably.
That's correct. So the English and Spanish scripts are both the American Collectors Association approved scripts. These are very simple demands. Any requests, again, I think the most important thing, just speaking from, I think the core of the question here is, idealistically, what would the best shops have in order to ensure that Rigoberto's grandmother isn't being treated like this? I can't really speak to that experience because I have no experience at all with as seen on TV type products or anything like that. Most of our purchases are from these major financial institutions. That being said, the examples of affinity card products or affinity products are a real concern because, again, back to the idealistic understanding of this, it would be simply to ensure that you have documented and systematic controls to ensure that those that speak in a language other than English can be spoken to by someone that is speaking that same language, as well as having the proper checks and balances to make sure that they're not straying from script. I am not a fluent Mandarin speaker. It would be very difficult for me to know whether or not my collector that's speaking Mandarin is pushing the envelope. The good news is, we have other controls. I have a bookkeeper that speaks Mandarin, so we can review those calls and ensure that they're consistent with that basic standard that we've set forth.
Is that rare to find that level of, the script in the language of origin with the collector speaking the language of origin with the supervisor who supervises the collector?
It's a good question. So for us, it's about aligning with good partners as well. So we have an internal collection shop, but we also we outsource to other collection agencies across the United States. And one of the things we've instructed our collection agencies, especially when you start talking about those that are in the Midwest or the Northeast, if they run across somebody that is a Spanish speaker, we just have them close the account out, return it back to us, because we know we can do a better job of handling that. On the same token, I had spoken about how we had purchased a retail contract, and this is 10 years ago, but that was primarily Spanish-speaking in the Los Angeles area, a furniture store, not Aaron's, that we identified that a large percentage of the consumers within that file were non-English speaking consumers. And so with that, we found the right agency partnership, an agency that has 10 bilingual speakers that's able to handle that has the controls in place. And again, part of our due diligence is ensuring that our partners have that same level of compliance that we do. It's not easy, and it's definitely evolved drastically over the last 5 years, but it's a necessary model to keep compliant in today's climate.
So we know that often the debt collection process will start with a letter. Allison, Barney, Rigo, how are consumers perceiving that letter? Are folks coming into your offices clutching this letter saying, what does this say? I don't understand. Why am I getting this? Anybody speak to counseling folks after they receive a letter?
Usually when the clients come into my office, they've received these letters. They want to know what they mean. They want to know what they have to do. So generally, we can advise them, let's prepare a response within 30 days, and I explain what the document means to them. This isn't unique particularly to the Latino community. I have clients who speak English who have the same issues in understanding what these things mean. And a lot of times, it's not just one debt that they have, but they're getting a delusion of phone calls, and they're getting a mailbox full of these types of demand letters. So they're just overwhelmed, and they don't even know where to start. So we come in, I sit them down, and I walk them through it. It's a very time-consuming process, but it's important and necessary in order for people to understand their rights. One of the frustrating parts of my job is if I ever have to call a debt collector. It is a little slice of torture. I will call and say, hi, my name is Allison Snow. I'm an attorney. I represent so-and-so. And then I finally get directed to the right person after a considerable amount of time on hold. And when I get to the debt collector, they say, how much does your client want to pay? Well, my client has defenses to this debt that I'd like to discuss with an attorney. Can I speak with your attorney? Are you saying that your client's not going to pay the debt? Why aren't they going to pay their debt? They incurred the debt. Why aren't they going to pay their debt? And if I'm getting this as their attorney, I can only imagine what the client is getting when they call on their own. And just like Rigo's grandmother, it's an intimidating process and, quite frankly, an annoying process that a lot of people don't want to take time out of their lives to do. So they just give up. And that's what I see. I have to counsel people that dealing with debt collection and resolving credit report issues is a marathon, not a sprint. There's no magic wand to correct these issues. There's nothing magical about the process. It's going to take stamina to get us through this. So that being said, what I see a difference is when Latinos get these, that community tends to give more credence to the debt. They believe that they owe it more than traditional English speakers think. And so what I have to explain to them is their possible defenses, and I have to spend more time communicating with them to get them to understand that this is usually a third-party debt collection agency and what the debt collection agency has to do to prove it up. And then I know, because I also do the litigation end, so I know at the litigation end in our debt defense clinic, we have lost only about 1% of our cases, which is in direct contrast to average improper, who I would say about 1% win their cases. So as long as they have somebody who knows what's going on, they usually prevail because the lack of documentation, because of the problems with the origination of the contracts, because of all these different issues. But in general, I have a harder time explaining that with people who have limited English skills.
That's interesting. You've raised a number of interesting points. One thing we all talked about in a call before this roundtable is the fact that people often don't understand that their debt will change hands. And the confusion surrounding, ABC company calling that is completely unrelated to the visa or whatever debt, maybe to errands or whomever. And you're finding that both on the counseling side, but also in industry as well, that people are confused about the fact that their debt changed hands. Carla, can you speak to that?
Yes. When we are going through the counseling process with the clients, they don't understand why third party is calling them because, again, going back to the lack of information or documentation received. And so they don't understand why they have a third party, calling them. It's hard for them to understand, like you said, that debt is sold depending on the collection efforts. And during that counseling session, we try to educate the client and the consumer the process and that debt will be sold.
I think it creates two levels of confusion. One, the fact that many times the consumers don't identify with the debt. And we see, linked to that, a lot of times collectors trying to collect a debt that in fact doesn't belong to that consumer. It could be just mistaken identity, common name, or it could be some issue of identity theft. The consumer, is even more confused because they could have dealt, with a company, a name, where they disputed whatever situation they faced, and they felt that the end of that dispute had resolved, not paying that account. And now, 2 years later, 10 years later, they could get a phone call saying, you still owe this greater amount. Traditionally, when we get, a regular consumer who is disputing that that's his account, maybe just a common name, an error, we could tell them, hey, you check your credit report, see what else is in the credit report, dispute the accounts, and so on. I can just imagine telling my grandmother to check her credit report. I mean, it's like waiting to be slapped around because she's going to tell me, what do you mean? You're there to help me. That's why I paid for your school. You know, when you end up in these situations, our traditional way of assisting consumers just doesn't work. And again, you know, the people who call us traditionally are people who are nearly at that point. People who get a letter, you know, they ignore it. It's just another letter. They think that if they just ignore it, it's going to go away. And really, when they call us, because there's no place to run. Either they're being threatened, they're facing you know, a judgment, they're facing much more serious action, or it's at the point where their wages, their bank accounts are being garnished that they have to deal with.
If I may, during the counseling session, we do pull the credit report for clients, and so we take that time to educate them on where that collection account is, what are the things that they can do, and try to get them to understand that whole process so they don't have to do it alone.
Barney, have you had to unpack where the debt originated for some of?
Well, I wanted to raise one point. We passed it about 10 seconds ago, maybe, but I don't counsel clients, or we don't have walk-ins. I handle enforcement, so I pick up the pieces, you know, from the law enforcement side once a lot of bad stuff has happened. And one thing that I've seen with notices and letters and pamphlets to limited English speaking consumers is that often a translation will be included, but that, you know, there'll be an English portion and then a Spanish portion. The Spanish portion is woefully inadequate. So the terms and conditions and rights and warranties, et cetera, that are provided in the English section are not provided in the Spanish section, for instance. Rather, it's a mere summary. And so this strikes me as particularly sinister because it means that the draftee actually realized that they were going to be sending this to someone with a limited English proficiency, but actually chose to provide them with less information.
I want to remind the audience that if they have a question, they can write it on the card, and at some point just raise your hand if you have written out a question, and it'll be picked up and brought to the panel. When Allison you made this point that in your experience, a lot of the Latino community will give more credence to the debt than question its validity, which is actually one of the rights that consumers have under the Fair Debt Collection Practices Act, is to question and to request more information. And I know we've had a call before, and Rigo, you mentioned there's certain buzzwords that just don't translate into Spanish. Or when they do translate into Spanish, they carry a different meaning than they do in English. And can you speak to that a little bit?
I mean, exactly. Just as simple as an agency. When someone says, I'm calling from a debt collections agency, the word agency in Spanish means a government agency. And when a consumer hears that word, automatically they elevate the legitimacy of the person calling. And when they couple that with when saying we're calling from the legal department of this agency, you know, consumers are going to pay more attention. You know, unfortunately, I think that's done deliberately in many cases. And again, that will elicit a greater response, certainly more intimidation on the side of the consumer, because there's no such thing, you know, in Spanish. I mean, my take, it's a company collecting a debt, but that's not how it comes across when it's conveyed to the consumer.
So if you couple the word agencia with the bald eagle on the letterhead, then you get mass confusion. So the Fair Debt Collection Practices Act, as we know, requires certain notices to be given to the consumer. 809 requires, among other things, that the collector provide the consumer with the amount of the debt, the name of the creditor to whom the debt's owed, a statement that unless the consumer within 30 days after receipt of the notice disputes the validity of the debt or any portion of it, that the debt will be assumed to be valid. And there's a number of other notices. I mean, and that's a lot to convey to a consumer in English or in Spanish. And I just want to ask the panel, is it enough that that language just be properly translated into the language of origin, or do we need something more to have these notices be understood and to help especially limited English proficient consumers, know what their rights are and to help them assert their rights? Is it enough just to translate that language?
Personally speaking, I think that there has to be a little bit more than that. I think that the translation alone is not enough. Depending on the client's background and country of origin, different words mean different things. And so we have to, I think, provide more basic or more popular words when providing that translation.
Now, a lot of the themes we've touched on are deal with financial literacy. Are you finding even in the industry side that you're having to counsel or talk through the debt collection process and rights and the back and forth, even when your collectors are collecting from a consumer, whether limited English proficient or not?
You bring up financial literacy, and I think that Rigo has mirrored these same sentiments. For us especially, I can't speak for other agencies out there. A lot of these things that Rigo is indicating are things that I've run across in being involved on the board and hearing horror stories of these bit players making threats, whether those are threats of deportation or whether those are threats of immediate arrest. I think it's a very tough thing to say. Personally, I can only speak from my experience, and I can say that in my internal collection shop, if somebody said we're calling from the legal department, they're fired immediately. I mean, that's a clear violation of the laws that exist within this country as of today. But when it comes to education regarding consumer literacy from our side, our best goal is to educate as best as possible, to provide any documentation upon request, to try and explain what that documentation is. I know the later panels today are going to start getting into a lot of talk about the post-litigation collections on LEP consumers, and I think that that's where you'll really start to see where the lack of financial literacy, and I don't think it's just from us. It starts at the beginning. At a loan origination is where, whether it's the contracts, as Barney indicated, don't have proper or full and complete Spanish translation. I only have the information that I'm given from the originating companies. We do our best to explain it based upon that documentation and then make a deal. We're not, our litigation model, it constitutes less than 0.5% of our total inventory. So for me, I can't speak for the litigation model. I think there's probably some speakers that can speak more readily to that. But what I can say is that the component, the entirety of financial literacy is not only for our employees, for executive management, but doing our best job to explain the consumer debt substantially to the consumers that we're speaking to on the phone.
Absolutely, and I will add a little bit as well from in our shop. Zero tolerance for us. We have absolutely zero tolerance if anybody is saying anything different that they should not be saying. Exactly what Mark's shop is. We have zero tolerance. We have terminate upon immediately. We record 100% of our calls. We're constantly reviewing the calls. We have supervision, constantly barging in if they have to if the call is going in a different direction. We're constantly training, constantly coaching. We don't have the time. It's zero tolerance. It's not only because of the law, it's also because of our reputation as well as our clients. Our clients do not accept that. It's more of a customer service approach, educating, explaining. Yes, do we take a little longer and explaining on the phone call? But once they got off the phone, I believe that in most cases the limited English proficiency consumers now understand why they owe the bill, or now understand why they received the call, or now understand why they received the letter. So I think it's important that we all recognize, and I'm sure there's a lot of bad actors out there in our industry, and as far as I'm concerned, yeah, they shouldn't be in our industry, but I think in any industry out there, there's always some kind of bad actors. And in our shop, I can't reiterate more that it's just a zero tolerance. And we're here to assist the consumer, get the bill resolved, and then move forward.
Maricela, if I may add, that we are huge proponents of education. In fact, our department spearheaded an effort in the entire LA County, county departments for plain English, plain language, communicating with consumers in the level that they would understand. The surveys here in LA County show that the average LA County resident reads at the 7th grade level. And so when we looked at our materials, they were written at the 12th, 13th grade level. Clearly, we had a lot of room for improvement. All our literature was rewritten. But I have to add that it's not just plain language. It has to be meaningful information. And when you have a consumer, who is going through a process, they need to receive that information at the right point, at the right time. Not too early, not too late. And at the same time, that consumer needs to get instructions as to what to do if what we're dealing with, goes the wrong way. And I think a lot of our materials out there, they just basically tell consumers what not to do, what to look out for, but they don't tell them what to do instead. And when that's lacking, just human nature. People are going to do the things they do, and they're not going to call us until they're in trouble, when sometimes a little too late.
The one term that I would point out in these letters is the term validation. And even as an attorney, that's a fight to determine what validation means. A lot of times the debt collectors interpret it as just a print of the screen that they received, which has the person's name, the amount of the debt, maybe the person's social security number, maybe their address. And that's it. That's all you get for the validation. And so the term validation, I think, is very ambiguous and confusing, even to somebody with a graduate degree. And so I think those type of terms need to be reviewed as a regulation.
And you're talking about, this might be a consumer who says, who has asserted their rights and says, I want the validation notice, I want information about my debt. But it sounds like what we've heard is that a lot of LEP Latino consumers aren't getting to that point because they may be giving more credence to the debt or feeling like they must pay it, and they're also sometimes subject to different types of collection methods that might affect them differently than the average consumer. And I think someone raised threats of immigration, which, Barney, have you seen that in your cases?
Well, anecdotally, I've heard about it. Again, I don't counsel clients when they come in, and I haven't worked on any cases where that was an issue, but I'm in constant contact with Rigo's office, and I do know that, anecdotally at least, that is an issue out there.
And also some confusion about whether this third party is connected to the federal government, and whether or not resolving the debt with the third party is actually resolving a governmental issue versus a private issue. That's also sounds like often a misconception among the Latino community. Carla, did you have something to add? What are some of the best practices? I think we touched on it already. If we had, Allison, what do you think some of those best practices should be that debt collectors should employ when collecting from LEP Latino consumers?
I think one of the things would be to try and obtain from, as soon as they get the records, to require as part of their purchase agreements with the original creditors, to find out what language the document, or what language the contract was negotiated in, would be beneficial. That way the communications could start in Spanish. Another thing is, the first time you make the call, you just say, is it better in English or Spanish? You're not going to offend anybody by saying that. Is it better in English or Spanish? And then you can proceed in the right language. And then I would say debt collectors should be limited to, third-party debt collectors should be limited to saying that we're a third-party debt collection agency. They can't make representations about whether or not the contract was properly signed or whether or not the person actually owes the debt. but just that they've received this account. The account says that they owe the debt. They're relying on the information in the account. But my concern is that representations are being made that, look, you went into the hospital, you signed such and such a document, and so you owe the debt. But even in those type of cases I've seen where, for ambulance services, for example, so client crashes her boat into the side of a canyon wall and has to be life flighted out on a helicopter. If you ever have to be life flighted out, it's very expensive. It's like 45 grand. So she gets life flighted out and is taken away. So they asked if she had health care, and she had county medical services. Unfortunately, they took her across the state border when they life flighted her, so county medical services didn't cover it. They were going to charge $1,800 county medical services for the transportation, but they wanted to charge her $43,000 for it. Then she was totally unconscious when they did this. So when you get ambulance services or emergency services like this, you implicitly have a contract with them, but there's nothing express. You didn't sign anything, you didn't write anything. So in the case that we got, the statute of limitations had already expired because on implied contracts, it's only 2 years. And so you had the debt collectors telling her, look, you took the services, you owe the debt, and kept pursuing it. And as a result of the accident, she had disabilities, and so she couldn't deal with the calls, and she was ready to pay them. But I explained, because of the statute of limitations, this is a woman whose sole source of income now is Social Security disability, and paying for that would have made her homeless. And so, but she was so concerned about these calls that that's what she was ready to do. So one of the things is just to limit the third-party debt collectors to limiting what they have knowledge of. And if they don't have knowledge of the original contract, if they don't have the original contract in their hands, showing the person's signature and to not make the representation that they have a valid contract.
So the questions are piling up over here. I'm going to just start throwing out some questions from the audience. Is there a bare minimum of information that needs to be provided to a debt buyer? Why is it so difficult to obtain accurate information about the debt?
Yeah, the new California debt buyer law that came into effect several months ago does now prescribe minimum standards of information that has to be provided, and one important piece of that legislation is that the original creditor needs to provide at least the last statement, the thing that the actual piece of paper, a copy of the piece of paper that the consumer received, and that's a huge step towards providing proper documentation to debt buyers. But again, as I said at the outset of this, I would like to see even more documentation than that. I think debt buyers should strive to not just meet the law, but exceed it, and original creditors should strive as well. And original contracts, copies of original executed contracts, I think would go a long way.
Another question is, how often do you see problems due to similar names? Latinos have common first and last names.
Absolutely. Very common, very common. In our shop, again, we call the number that is given to us by our client, which is the hospital in this case. And if it's the right number, it's the right number. We also scrub to make sure it's the correct number that it was given, because sometimes in key registration in the front end, it could transpose some numbers, so we're kind of cautious when it comes to that. And depending on the demographic information that we've given, if we're given date of birth, social security number, more information, then we can move one step further, so we can do additional script tracing or tools that we have to locate if the number's no good. But if it comes with a very common name and there's no demographic information, then there's no such thing. We're not looking for that individual in that street where they apparently have given the address to. It's like trying to find a needle in a haystack, and it's just not going to happen.
Just to supplement what Albert's saying there, the verification, the first contact with any consumer, one of the most important factors of that is verifying that you're speaking to the right person. Third-party disclosure is a major issue. And just to give clarity to what we're talking about here, oftentimes you'll have Mark Naiman Jr., Mark Naiman III, Mark Naiman IV. And so when you contact a household and you say, can I speak to Mark Naiman? Oftentimes the person on the phone is going to say, well, you're talking to Mark Naiman. but it's not the right Mark name. And so then it goes on to, can you verify the last four of the social? Can you verify, the address? Some secondary form of verification to ensure that you're speaking to the right individual. It's a real issue, and again, by creating that secondary level of check and balances, you'll ensure that you're speaking to the right party as best as you can.
One of the things we see is consumers who are reluctant to divulge any additional information in the verification process. One, they've been burned in the past. In instances where they're saying, well, I'm not the right person, and the person on the phone says, well, give me your social security number so I can verify that, you can see that they're not going to provide that because they're just unwilling. The other thing that we see related to that, it's consumers making repeated requests to stop the contact. I'm not the right person, do not call me again. Being at my grandmother's place one time, the phone rang, she picked up, said, don't call me. It rings again in 5 minutes. I pick up, I tell the person, do not call. 5 times he called back within the 10, 15 minutes. This was a big debt collection agency out of San Diego. It wasn't just a rogue, outfit. So when the consumer makes clear requests, especially, a lot of times consumers, they just don't want to be called. Even if they can deal with the debt, that phone ringing constantly, and I think that's why that statute at the state and federal level provides that right. Once you make that request, we tell consumers, do it in writing, send it certified mail, and they just basically say, I did it, I've done it, and the calls just keep coming. So I think that would be definitely a best business practice. When someone makes that request, that I'm not the person, don't call me, well, do a little research. Perhaps, tie it back to the original purchase where clearly, it was done in a way that the consumer is not responsible for that debt.
You touched on another important point that we had discussed on a pre-panel call. I think, Allison, you had mentioned that in your experience, the Latino community is more readily gives out their personal identifying information to someone on the other line, so more readily shares Social Security numbers. And you talked about an interesting ramification of that as a result, that information then becomes part of the file.
Right. A lot of times, the debt collectors will call and say, okay, I need additional information to verify. Please give me your last 4 of your social. And so the person will offer up the last 4 of their social. And so the next time they call, they just say, okay, I have your social here. It's blah, 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 blah. And it's what you just provided to them. And so a lot of times the consumers will be like, well, you're the one who called me. If they're a good consumer that I've taught and they're doing what they're supposed to, they'll say, why don't you tell me what you have, and I'll tell you if that's me or not. Because otherwise, they now have additional information. And so when I've gotten into litigation at the end, and I can subpoena the documents from them, and I get the documents, and we can actually see where the client's Social Security has been added to the account. So they had a different Social Security number, didn't inform the client, and then they added our client's Social Security to that account. And it's not that uncommon where additional information will be added just because our clients have offered it, which is one of the reasons why they're reluctant, or why they should be reluctant to give over that identifying information, and the creditor should offer the information it has in order to verify the information and not the other way around.
So it sounds like the community also needs to be educated to protect their personal identifying information and the reason why that information should be protected. One, it can become part of a file, or it can be used for identity theft and whatnot, or and then forevermore, if it does become part of a file, it's pretty difficult, I think, to then disconnect yourself from that particular debt.
And it builds up to the credit report as well. Once it gets reported, it links the new social with the profile. I was at the Supercuts or Fantastic Sam's the other day for a haircut, and I was waiting in the lobby. And when people were signing in for their haircut, the person behind the counter was asking them for the phone number. I just looked at it. It was about 5 people in front of me. All the Latino consumers gave their phone number. And there was another lady, she said, I'm not giving you my phone number. And when I came up, she said, what's your phone number? And I said, I don't share my phone number. And she looked at me like something was wrong with me. It is part of the culture that I don't know what it is, especially when you're not familiar with the language and the system, you just tend to be a little more flexible with your information. I was going to ask if we could get people asking the questions, if they could tell us what agency they are from so we can kind of frame it.
Yeah, these are anonymous. I know we have a question from someone with Telemundo. Thank you. Thank you. Thank you very much. So another question from the audience. Now these are anonymous questions. So Nevada has rules for licensed collection agencies that correspond in writing with consumers in Spanish to have those letters reviewed and certified by a court-certified translator before sending them. What does the panel think about that as an additional control against misleading communications to Spanish-speaking consumers?
I will comment on that. We currently do that today. And the reason why we changed doing that, probably about 5 to 8 years ago, we went through the court reporting translation process, is because of the fact my Spanish could be totally different than any of you guys when translating something from English to Spanish. So we were doing that internally through a Spanish speaker that may be from one Latin country, and another employee from another Latin country said, no, that's not proper Spanish. And so when we were notifying the consumers, we would also get the feedback to say, well, that's not proper Spanish. So we just decided to go through the court reporting process for the translation process, and that's worked very effectively for us.
Does the panel support the use of independent debt registries to improve consumer transparency of debt ownership and supporting information?
I'm not sure I understand the question. Independent,
So
how would they do that?
I can touch on this. I don't know how comfortable I am talking about it, but so the concept here is that there are companies that are suggesting that they will maintain a database of cradle to grave, and what I mean by cradle to grave is origination down through a collection agency or a debt buyer, and then all the way to a finalization or once that account is out of stat. And I can try to kind of mold this back to the last question that somebody else asked regarding how do you feel about Nevada. All 50 states have different laws. Barney was speaking about Senate Bill 233 in California that was passed. One of the biggest, and again, just to harken back to another question, is idealistically, every collection company out there should have a full-time chief compliance officer. It's that individual's responsibility not only to make sure that we're up to date on all these 50 states' regulations, but to move towards this debt registry question. It's an idealistic concept in that the originator would report to a debt registry the name and some let's just call it some key attributes of that account, the amount of the account, the original account number, the date it was opened, the date it charged off. Again, rough man's example here. And then if they transferred that account to ABC Collection Agency or ABC Debt Buyer, that debt buyer would then be required to list that on this registry and indicate that they purchased it on this date, and the balance on that account was transferred in accordance. It either went up or it went down based on interest or fees or payments post-charge-off. And then there's almost the ability that the consumer would have to pick up and call an 800 number and find out exactly where their debt was at any time. This is something that's been in the industry, that's been talked about for the last, I want to say 7 years, 6 or 7 years, realistically. I think, you know, speaking personally about it, I think idealistically it makes a lot of sense. Putting it into place, I think, is a much more difficult process as the banks themselves have concerns over essentially creating, for lack of a better term, kind of this Death Star repository of all consumer information within the United States. We've seen data breaches that have taken place with some of the largest financial institutions, some of the largest retail companies out there. And so the flip side of this thing is, by putting all of this information into one area, is it not becoming kind of more of a risk? And I mean, it's a very interesting solution, idealistic solution. I think in practice it needs some adjustment or some type of revision to really become a successful concept.
I think to some extent we have forms of that for different types of debts. So say, for example, in the student loan industry, a lot of these have been packaged and sold on the securities exchange, and just like mortgages. And so those packages, when they're bundled up, are reported in the SEC filings, and we can go back through and I can trace a student loan. If it was included in this package, I can follow it on the SEC website and kind of create a path of what's happened to that debt. And so I think maybe if it's not as specific as containing a person's personal information, personal identifying information, but at least in these purchase-sale agreements, if the purchase-sale agreement is identified and is tracked, I think that might be a good solution.
It is pretty similar, and I was written up the other day to registering a car. Every car that is registered in the United States gets logged in, and when the system works, if the car has tickets, if it's been flooded, all kinds of issues. I think such a register could work similarly. I agree that it would need, vetting to make sure that it works, and that potential of security issues. I wanted to add just, one thing that we see generally, debt collectors from a different state collecting debts in California. And especially the more abusive ones, Florida, New Jersey, different places, and vice versa. We see a lot of companies here in the Valley that are targeting consumers out in other states, and there's a reason. One, they're hard to reach if there is a dispute on the debt, and when we start getting those complaints, especially at the local level, for us to build a case, it's nearly impossible. We've been talking about this through the California Consumer Affairs Association for the last 6-8 years. And one of the recommendations that came up a couple of years ago, is looking at whether collection agencies, debt collectors should be licensed in the state of California. if they should be bonded. Just about every industry that we deal with, contractors, they have a bond, they have a registration, they have a person that is designated as the go-to in case things go wrong. I mean, the chief compliant officer, the agent for service, whomever is designated. I think honest debt collectors have those systems in place. I think is the ones that we're having to deal with that don't. And something like that, to explore whether that's, feasible, a possibility, I think could go, make some stride in getting additional protections for consumers.
So a lot of members of the audience are very curious about statute of limitations. What information is given to a consumer in the course of debt collection? What do the enforcement attorneys see, but also what information are you giving your consumers on the statute of limitations and their debt?
Well, it's unfortunate because statute of limitations still permits the debt collector to bring suit. It's an affirmative defense that needs to be raised by the consumer. And so unfortunately, we have seen, at least historically, that statute of limitations does not prevent debt collectors from chasing down debts that are effectively unlitigatable.
Every state is different statute of limitations. So in talking about California, you got your 4-year statute of limitations for litigation, as Barney's saying, but it doesn't prevent third-party collection agencies to kind of ask for the money if it's owed, whether it's through a debt buying process or through it's just a late assignment. You do have accounts, not necessarily assigning after 4 years when it's from the first party creditor to the third party agency, but you do have that, I'm sure, in the debt buying aspect of it.
I think Ted Merman is in the audience, and on the debt buyers, I think there's now a change in the law that requires the debt collector to inform the court whether the statute has run out or not, and if it has, that they cannot file the case. Maybe a little off.
No, so I think that what you might be referring to is like I said, DBA International put forth a certification program for all members in 2012. Again, one of those is ensuring that statute of limitations is followed. Barney's 100% right. It's an affirmative defense. What I can tell you is the people that are still litigating on out-of-stat consumers are few and far between. These are people that are using that antiquated methodology of, let's use the affirmative defense. In this day and age, especially with the advent of the CFPB portal, we keep talking about ways that consumers can reach out and educate themselves. The CFPB now maintains a portal where complaints can be filed. I can tell you that of the 400 or 500 members of DBA International, I don't know of any that are actively suing on out-of-statute accounts. You'd asked me 10 years ago, I'd say I probably knew a few, but that's changed greatly over the last 5 years especially.
We also, a good chunk of the complaints are debts that are out of statute. And when the collector calls the consumer, is to figure out a way to have them reaffirm the debt. So you get the call on a 10-year-old account, and the person says, we're the good guys. We're here to help you pay this account. We know that it's been bothering you for 10 years. And just send us, $5 and say that you're going to pay whatever you can. The minute the consumer sends the $10, that triggers again the 4-year. And you can, then we get the call saying, it's been this long, and now they just file a lawsuit because now they have a new statute of limitations. So, it is the deception, because you can see very clearly that it was, how the consumer was tricked into reaffirming the debt. So when we get those calls, in our department, we are extremely careful not to, advise the consumer about their legal rights, because that could be to their detriment it would tell them to work out some sort of a deal, when in fact the statute could have run out.
Another question asked, to say, we had multiple collection agencies trying to collect a debt from a single account. And the question was posed to enforcement, what are the enforcement agencies doing to prevent this from happening? And so I want to kick it to both sides. What does industry do to prevent the multiple collection? Or what do you do when you find out that someone else is trying to collect on the very same account? Albert or Mark?
Very rarely do we see that, but there has been situations when we've seen that, when a healthcare client has two agencies and simultaneously either it's an alpha split, and the daughter or son has a different last name, and so we're collecting on the consumer, who's the mother or the father, and the other agency's collecting on the daughter or the son with a different last name. So obviously they're asking. So you kind of see that happening, and then either one of them, once we identify that, either one of the agencies will recall, and we'll bundle them together and we'll collect from there. So once we're notified that they're being called from two different entities, then that's the direction we go.
I really can't add too much to what Albert says. It's a rare occurrence in purchasing an account that an originator has either placed that account or not recalled that account from a previous agency. Has it happened in 14 years? Sure, once or twice. Again, having a chain of communication back to the originator to find out what's going on, the account immediately goes on into hold. And to again speak on something we touched on before, having a robust dispute resolutions department in-house, not just a collector that uses a status, but having a department that is overseen by a chief compliance officer, by someone in executive management that can handle this type of thing, escalate it, so that it doesn't turn into a festering type of a situation where continued calls. Put the account on hold, let's do some investigation on our side, and then, depending on what our findings are, really dictates what our actions are.
I think from my standpoint, I actually have two cases right now that are dealing with this issue. I have an American Express card he has 4 different debt collectors coming after him for the same debt. And then another one is a mortgage case where there's 3 different debt collectors all coming after him, but then we've sent validation notices out in that case, and not one of them has replied to the validation notice. So we don't know who has the account, and it's pretty confusing. So it does happen in the industry, and so the client basically has to do a lot of the work, which is to ask for validation from each of the different creditors, figure out which ones are trying to collect the debt without the right to do so, or it may be an original creditor problem, and the original creditor just keeps selling the same account over and over again, and then they have affirmative claims against the original creditor, or they have claims against the debt collector who doesn't actually own the account. And so those are how we approach it, but it is a problem. It does happen. The computer systems aren't perfect, and neither are the people who are putting in the information, and sometimes the same debt gets resold several times to different debt collectors.
When we get that type of complaint, which we do get regularly, we work not just with the debt collector to address the dispute, and when the debt collector says, sure, we're going to send back the account to the original creditor, we make sure that we go to the original creditor so it doesn't get shelved for a year and then resold again and then again and again. The New York Times Magazine a couple of months ago had an in-depth story about the debt buying industry, and they outlined how these debt buyers would not only steal portfolios from one another, to go collect the debt, sometimes simultaneously, sometimes one after the other. And clearly those are the more extreme, type of cases, but those are generally the ones that come to us because that's when consumers really don't have another thing to do.
Someone asked, is there more shame or guilt associated with owing a debt in the Latino culture? Does anybody have any thoughts on that?
I can tell you my grandmother would do whatever not to let her comadre know that she didn't pay her account.
I can just speak personally, anecdotally. My father had a practice of paying everything in cash because he couldn't stand the idea of owing anybody anything. So I don't know, I think that he might be typical of the men in his family.
I think one of the issues too is a lot of times in the Latin community, debt is a family issue. So I see a lot more co-signing on loans. My mother would never co-sign on a car with me. But in the Latin community, you see that a lot more. And so I think there's a lot of guilt too involved. If you default on a debt, usually you're impacting your mom, your grandparents, your uncle, whoever co-signed with you on the debt. So it's more of a familial issue. And I think to that extent, it carries with it more at least guilt.
Yeah, that is a good point. And I do see that in my own family, and I've seen it with the consumers that I've talked to, that it's a family affair. And so, you have the kids calling the enforcement attorneys about their grandmother's debt that 3 other people in the family got a call on, and everybody in the family pitched in to pay. So, these are just anecdotes from cases that I've had and calls that I've had, but it is more of it seems like a family affair in the Latino community.
Well, I think it's also natural that a lot of, Spanish speakers, they're recent immigrants, so they don't have a credit. And when they want to buy a car, they're going to bring somebody to co-sign for them in order to get the loan. And so by, default, they end up being more than one person responsible for that account.
Are there any other terms that have negative connotations when translated in Spanish, like agencia, or unintended connotations? Abogado, notario. Can someone speak to certain terms that don't track or translate well? So agencia being a big one in debt collection, but notario fraud too. I think sometimes people think notarios are attorneys, and I know I've seen certain debt collection shops that are collecting in Spanish use the name notario. Licenciado, which means, can you explain the background?
Licenciado in some countries could be someone having a bachelor's degree. In some other countries, it could be an attorney.
It's just the concept of going to court. I can, think back to Mexico. When you face the prospect of going to court in Mexico, it's huge. It's not like going to small claims here. There's no such thing in Mexico with small claims. People are just, in general, a lot more, traumatized by the experience of going to court. And when someone on the phone is saying, I'm from the legal department, and you pay, it's not whether you're going to pay, it's you're going to pay one way or another, or else we're going to court. That threat, I think, has a lot more bearing on someone who comes from a country with that type of, fear of the court system than someone here who might be a little more familiar with how it plays out. Debtors in prison, some Latin American countries still have that. We clearly don't have that here.
I'm sorry, the last point, the debtor's prison that some folks come from.
Exactly. There are some countries where, you don't pay your debt. I don't know if you remember the incident a couple of years ago, the American tourist that was down in Ensenada. He got in a car accident, and it just so happened that the person in the other car was a government official, and they wouldn't let him leave until he showed the American tourist, proof that he had the ability to pay for the damages to the other car. When you have that kind of experience, living and growing in those countries, it's different. You have to really understand their psychology.
So generalizing the legal system from back home, generalizing it to the United States and misunderstanding what your rights might be here is a big problem. Now this question goes back to the multiple collectors trying to attempt to collect on an account, or it's related. Someone asked, sometimes multiple calls are made on the same account, not at the same time, but at different times, maybe years apart. Do collectors typically transfer the results of contacts in a file that gets sold to another collector? Is there a list or a recording of every contact with the consumer in the file that that passes hands?
In our experience, there are some of our clients do want us, after a 6-month or a year period of time of us attempting to collect the debt, to transfer it over back to them, and then they go to what's called a tertiary collection agency. It's not sold, it's just another level of trying to collect the debt. And our requirement is to provide them all of our notes, all our communication, anything that we've done on the account. And I'm assuming that the tertiary agency is uploading that data or has access to that data, so when they're actually communicating, they know what conversations they've had with us, if any, at all.
I think what Albert is describing would be considered a best practice, and that's maybe done because it is the same original creditor, just working with different vendors. In my experience, the absolute minimal information possible is given to the debt purchaser, and so it's going to be amount, name, address. The idea of call log information being passed on is not something I've ever seen.
Well, I have a question for you specifically, Mr. Eskandari. What are the most common types of collection cases you're handling?
I can't get into the details, but we do have a pending lawsuit against Chase Bank, and I think probably the sorts of suits out of that case are indicative of similar suits by other large banks, and they're very high volume. They are appear to comply with all aspects of the law, when in reality, procedural requirements maybe have not been followed, and with an eye towards the consumer actually not showing up. In these sorts of cases, consumers have many collection attempts, or some collection attempts have taken place. The consumer is not paying. It gets referred to litigation. And when it gets to that point, that usually still doesn't get the consumer to pay. And so the bank ends up with a default judgment against the consumer, which then ends up haunting that consumer and ruining their credit for many years potentially. It is a way to change where debt has a 4-year statute of limitations. It can increase the amount of time that debt continues to haunt the consumer. And so I think that's fairly standard practice for big banks and how they collect on credit card debt.
This question is for Allison. Does your organization provide services for consumers to file lawsuits under the FDCPA against deceptive or abusive practices to recover statutory damages and attorney's fees? And if not, should that be done more?
We do. I love to do it. We do. I created the debt defense clinics because they were overwhelming my practice. And these are routine cases. The plaintiffs handle them like a mill, and I said we have to have some kind of response. We can't keep treating these as individual cases. So I created the debt defense clinics, where we've systemized the way we handle these debts, and we're very successful at what we do. And that frees me up to go and file affirmative claims. So we practice in both state and federal court, and we do a lot of effort to enforce these actions. And because of what we've done, legal aid typically cannot get attorney's fees, but in these cases where we prevail, we're able to obtain the attorney's fees, and that's been able to help fund our program. So it's been able to fund the clinics, and it allowed us to hire additional attorneys into our program to help with these types of cases. So it's a very successful practice. We had one gentleman who, he was 19 years old, disabled, went into a gym and wanted to get skinny. And he didn't have the capacity to sign a contract. He told them that he didn't have the capacity to sign the contract. He had gone in with another buddy. They got the buddy to sign up as the buyer and him as a user. But then when they came to collect the debt, they said, well, you signed the contract, even though he's not obligated in any way under the contract. You signed the contract, you have to pay. They hadn't filed a lawsuit yet, but they told him he's a Spanish speaker, but does speak some English, and so he's communicating with them in English, but they tell him, we filed in the state district and venue of California, which to an attorney would know that that's gobbledygook. But for him, it was extremely scary. He calls his mom yells at him, he calls his buddy yells at him, and he's so upset about this that he actually starts to take a handful of pills because he's so stressed out. Luckily, a Good Samaritan from his church called him right about that time and talked him down off the ledge. But it was very upsetting to him, so we were able to file a lawsuit, and the client recovered almost $100,000 in that case. So they're good cases. When they're particularly egregious, we're able to go after the bad debt collectors.
This is a question for the industry folks. Do you ever just let go of collection efforts on a debt because the documentation or the information is so lacking? Was that a softball?
No doubt.
Okay, good. So yes. And this is actually a,
Someone has a question.
So oftentimes, just from an overview, when we're purchasing from originating financial institutions, within the purchase and sale agreement, we get a guaranteed percentage of documents. Any accounts that don't meet that percentage are oftentimes able to be returned back to the original creditor as what's called a repurchasable account. So I can submit that back to the original creditor for my purchase price. They refund the money. Because again, in this day and age, and I think that both Albert and Barney talked about this, everything is about risk mitigation. So where 10 years ago, it was basically my problem, like, well, we would just write the accounts off. They'd go into a inactive desk and, they just sit there for all eternity. Now, I think originators are trying to find that middle ground by which on accounts where we have identified documentation deficiencies, and it's most applicable in auto, that we can return these accounts back to the bank, get our money back, and we're not sitting on those accounts forever. With the original, well, of course, when we're purchasing accounts from any financial institution, there's a contract that goes into place that governs the overall content of that deal and the rights that we have, indemnifications and standard purchase and sale agreement. Yes, theoretically, again, debt sales has changed so much over the last couple of years. Most originating creditors are now restricting resale of debt. So we've found ourselves in a position where we are we purchase it, we can outsource it, but we can never resell that debt. But yes, speaking back historically to debt sales, there is a contract that is between every individual company that purchases that debt from the originator all the way down to whoever that owner is, and a bill of sale that identifies the number of accounts transferred, the face value of those accounts, and some other attributes of that file. No, I'm saying that in the past, debt sales, that most of the originators did not have a restriction on resale if you go back 5 or 6 years. And so by today's standards, any third-party debt buyer that purchases from the banks does not have the ability to resell those accounts 4 or 5 hands down the chain. Go back 10 years, they didn't have those same restrictions in place. And so a lot of these stories that we're hearing about is where, a good reputable company purchased those accounts, sold it to someone, who sold it to someone else, who sold it to someone else, and by the time it's 5 or 6 or 7 hands down the chain, look, if you play a game of telephone, and that's really what a lot of these issues, the game telephone, you start here, I say, cucumber. By the time it gets, down here to Albert, so all of a sudden it's, Polish sausage. I mean,
that's why you need a script that says cucumber in Spanish.
That's right. And so, that really talks about what the issue was, is that there's no.
So I don't want to cut off the discussion. We're going to have a break in a minute, but this is a good place to end. And this is a question probably best suited for Carla. Where does one start to check to check where they could get resources about finding out about their credit report, about debt counseling, without feeling that they're paying for this, services that aren't going to work.
I think that it's important for every organization, nonprofit providing financial education to get as many partners as possible, providing that information so that it is readily available. I also think that going out into the community, doing fairs, doing workshops, doing events does help spread out the word. So I think the key is partnering up with as many agencies and providing the information, letting the consumers know that the resources are available for free. We are here to help educate them so that they can make better decisions.
All right. Well, thank you very much. We've hit our time limit, but we will all be around the rest of the day. So please feel free to come up to us and ask us any questions. Thank you.